Good evening, Saitlanders. How are you? We hope, as ever, that all is well. My favorite scholar in South Africa is hands down Dr. Anthea Jeffrey. For the sake of her scholarly or academic integrity, because she works for the Institute for Race Relations, which has historically been a liberal entity. Liberal certainly by the standards of Saitlanders, by the standard of behoudenness, by the standards of conservatives. And certainly by the standards of, I'd like to believe, conservative Christians. And she wrote on the Daily Friend, dailyfriend.co.za, published on the 15th of October, an article entitled "Don't Drink the Kool-Aid on This Expropriation Bill Either." Now, for those of you who don't know the reference, the parable, the metaphor, whatever it is, I don't know the details of this story very well, but there was a pastor called Jim Jones who took his parishioners, his congregation, I suppose, from the United States of America to Guyana in the West Indies. Guyana is it's a part of South America, but it counts as the West Indies. You know, they play West Indies cricket, that kind of semi part of the Caribbean. And they set up this was in the late 70s, I think. And they set up a sort of a compound there, this cult, because that's what it amounted to. And eventually he had them all commit mass suicide by drinking poisoned Kool-Aid. I can't remember what poison it was, strychnine or arsenic or who knows. Anyway, so don't drink the Kool-Aid. Don't participate in suicide. Don't get beguiled, gekil, tricked, conned into drinking the Kool-Aid, because it's harmful to you. And it runs as follows, the article. The Expropriation Bill of 2020, which is essentially the same as its 2019 predecessor, was gazetted last week. So it was gazetted in the Government Gazette. It is intended to supplement the Expropriation Without Compensation Constitutional Amendment Bill, which is now being rushed through the final stages of the public consultation process so that the ad hoc committee can present it to Parliament for adoption before the end of the year. I should clarify one thing. The Expropriation Without Compensation Constitutional Amendment Bill refers to the bill to amend Section 25 of the Constitution, which protects property rights, to allow, constitutionally speaking, for land or property to be expropriated without compensation. That's one thing. That's the change to the Constitution. Separate to that, she's referring to the Expropriation Bill of 2020, is the Act of Parliament, which will then flesh out or substantiate or articulate the provisions of the constitutional amendment. Let's say, for example, in a constitution it says that elderly people are entitled to physical support. Jolly good. You will then usually have an act of Parliament that elaborates upon that, saying that when people reach the age of 59 years and 71 days, they will be entitled to one walking stick made out of such and such a category of wood at such and such a cost. Do you know what I mean? Okay. She goes on to write, even without the EWC Constitutional Amendment Bill, the Expropriation Bill, the Act of Parliament, will allow property of many kinds. So even without the change to the Constitution, this other bill, this Act of Parliament, will allow property of many kinds, not only land, to be confiscated by municipalities and other organs of state for no or inadequate compensation. According to the bill, it may be just and equitable for nil compensation to be paid for expropriated land which, now we have a series of bullet points, is unused but is being held in the hope of its appreciating in value over time. So in other words, if you invest in a piece of land and you don't make use of it, you've invested in it purely as an investment, well, then they can take it for mahala. Bullet point number 2, which has been abandoned by failing to exercise control over it. And there doesn't appear to be much more definition than that. So in other words, if you're not on the land 24 hours a day, technically, theoretically, possibly controlling it fully all of the time, then it is abandoned because you were failing to exercise control over it. Bullet point 3, poses a health, safety, or physical risk to others. I have no idea what is the pertinence of that. I mean, I just can't understand it. But that's what it provides. Is worth less, this is number 4, land which is worth less than the state subsidies from which it has benefited. So in other words, if the state is somehow subsidizing that land, how, I don't know. Presumably one form of state subsidy would be tax write-off. Okay, land worth less than the state subsidies from which it has benefited. Or, bullet point number 5, the final one, is owned by a state-owned entity which is not using it and consents to the expropriation. So, if you're a private landowner and you're not camping on your land 24 hours a day to maintain proper control over it, consent doesn't come into the matter. But if you're a state-owned entity, you can consent or deny consent, refuse, object. She goes on to write, this list with its 5 examples is intended to reassure South Africans that expropriation without compensation will be sparingly used and justifiably applied. However, the circumstances in which nil compensation may be paid for land are expressly not limited to those set out in the bill. They may thus extend far beyond this short list. Can you believe that? It's like making a law in which you say a guy can be arrested, a person can be arrested for the abuse of alcohol if they do X, Y, Z, A, B, and C. And if they do any number of other things which we haven't mentioned. Do you flaming believe this? The bill also empowers all municipalities, along with various other state entities at higher levels of government than municipal level, to expropriate land and other property by following a set of specified procedures. These procedures are heavily skewed against the owner and in favor of the government. Hey guys, this is not good. Under the bill, a municipality which wants to expropriate residential or other land, say to reduce spatial apartheid and build RDP houses must begin by investigating the property and negotiating for its purchase with the owner. If no agreement is reached, the municipality may issue a notice of its intention to expropriate. In this document, it must invite representations on the proposed expropriation and the compensation to be paid. The municipality is obliged to consider any representations received, but it need not respond to them. It need not even respond to them or give reasons for rejecting them. Once it has taken these simple preliminary steps, the municipality may issue a notice of expropriation. Simple preliminary steps, to put it mildly. Under this notice, both ownership and the right to possess the property will automatically pass to it, the municipality, on the dates set out in the notice. Guys, if this is not a recipe for disaster, if it's not a recipe for abuse, if it's not a recipe for the wholesale, prejudicial, grabbing of privately owned property in South Africa, then I don't know whatever could possibly be. The date for the transfer of ownership could be a mere week after the service of the notice. And in parenthesis here, the only time limit in the bill is that this date must not be earlier than the date of service of the notice. So if you get it, if the municipality serves notice to you at 3:30 in the afternoon, it can be effective 8:30 the next morning. The right to possess the property could pass to the municipality within another week. The owner may seek mediation or apply directly to the courts to challenge the validity of the expropriation and the amount of compensation offered. However, most people will lack the means for such legal challenges and will find them particularly difficult to mount if they have already lost ownership and possessions of their homes or other key assets. She uses the word key here in a different context, obviously, but it makes me think of the word key as in key in a lock. If you've already lost the keys to the gate, the chances of you getting the courts to give you that property back are just about nil. Expropriated owners will also, it seems, bear the onus of proving that the compensation offered is insufficient and may have to pay much of the municipality's legal costs as well as their own if they fail to convince the presiding magistrate or judge of this. Mense, this is not funny. Expropriated owners will also be able to seek relief in the courts if the compensation remains unpaid for months or years after ownership and possession have passed to the municipality. Can you imagine something like this being done in Renosterberg municipality, where we have no money because they stole it all of it? So much so that Renosterberg municipality has not paid over, this is a fact, the municipality composed of Van der Kloof, Pietersville and Phillipstown has not paid over the pension fund contributions deducted from employees' salaries. So the deductions are being made but not being paid over to the pension funds since September 2017. Can you believe that? That is an act of cruelty even by African National Congress, South African Communist Party Alliance standards. Amen. Oh, and our municipal staff were not paid their wages at the end of October. In practice, however, most people will lack the means for such litigation. Blah, blah, blah. Under the bill, law-abiding homeowners will have fewer rights than criminals illegally using a warehouse they own to store heroin. Though the warehouse may be seized by the state, this can only be done after its use for criminal purposes has been proven and a court order for its confiscation has been obtained. But a home can be expropriated by a municipality by following the simple steps set out above, and without ever having to prove to a court that the expropriation is really in the public interest or that the compensation is truly just and equitable. Perversely, the bill acknowledges the need for a prior court order before a municipality can enter onto property it wants to investigate with a view to subsequently expropriating it. So in other words, it has to get a court order before, but not after. You have to get your own court order or bring your own action to stop the process. So it has to get a court order, the municipality, to come onto your land to have a look at it. After that, no court process involved unless you initiate an action to prevent the seizure. It also says that a temporary expropriation order cannot be extended without a prior court order. But when it comes to the far more serious matter of a permanent expropriation, the bill excludes the need for a prior court order. Yo. Guys, I encourage all of you Saitlanders to read this article by Anthea Jeffrey. It goes on for a little bit longer. This video is now 17.5 minutes long. It would be close to, well, I suppose 25 or going on for 30 minutes long if I was to read the whole thing. And I know that it is discouraging to some people to have to watch long videos. Therefore, let's leave it at that. I'm sure we'll talk again on this subject before too long. It's very serious, guys. It's very, very serious. Anyway, all of the best to all of you. Take good care of yourselves and your loved ones. Cheerio. Bye-bye.